Have you been terminated from your job? Are you wondering if your employer was allowed to terminate your employment? Here's what the law says. The Employment Standards Act, or the ESA, is a law created by the Province of Ontario which provides basic rights to non-unionized, provincially regulated workers. This means that if you're in a union, you should get advice about your rights from your union or a labor lawyer. If you're a federally regulated worker, meaning a worker covered by the Canada Labour Code, then the ESA doesn't apply to you. You have different rights around termination. If you are a non-unionized, provincially regulated worker, the ESA says your employer can terminate you without notice or pay if you've been employed for less than 3 months. If you have been employed for over 3 months, you're entitled to 1 week of wages for every year of service with your employer for being terminated. This is called termination pay or pay in lieu of notice. You're also supposed to receive a letter from your employer telling you that you are being terminated. If your employer pays you termination pay and provides you with a letter, they have followed the law. If there is no reason provided for why you are being terminated, then this is called a without cause termination. Some workers may also be entitled to additional money called severance pay through the Employment Standards Act if they've been employed with the same employer for over 5 years and the employer has a global payroll of $2.5 million. If your employer doesn't pay you termination pay when you are terminated, you may want to get legal advice about your options. Some employers will refuse to provide termination pay if they think you committed willful misconduct, disobedience, or willful neglect of duty that isn't trivial and hasn't been condoned by the employer. You can take steps to receive your termination pay and severance pay through the Ministry of Labour. You must file a claim with the Ministry of Labour no later than 2 years from when the termination occurred. However, if you file a claim with the Ministry of Labour for termination pay, you will not be able to also pursue a claim in court for wrongful dismissal. A claim for wrongful dismissal is when a worker asks the court to award them reasonable notice damages, which is money for the period of time the court thinks it will take you to find a new job, based on your age, length of service, type of job, and availability of similar employment. What you can do. Generally, it is a good idea to get legal advice before taking action against your former employer. Legal counsel can help you figure out if you have a good case for wrongful dismissal, or if there are any other types of compensation you may be entitled to receive. Make sure you file for employment insurance benefits after the termination. This compensation may help you make ends meet while you're looking for a new job. Going after your former employer for additional compensation can take time, especially if your case has to go to trial. You should know that sometimes a termination may be illegal. Examples of illegal terminations are reprisals or terminations that are discriminatory. If a factor in the decision to terminate you was discriminatory, meaning in violation of the Human Rights Code, or if it was meant to punish you for asking about your rights under the Employment Standards Act or Occupational Health and Safety Act, then it may be illegal. If you think this applies to you, get legal advice right away as there are deadlines to file claims related to discrimination and reprisal. For more information about your workplace rights, visit www.WRCLS.ca or www.stepstojustice.ca. You can also contact Waterloo Region Community Legal Services at www.wrcls.ca/web contact, or give us a call at 519-743-0254. Check out our YouTube channel for more videos.